Good morning and welcome to the fourth meeting of the Equalities and Human Rights Committee for 2020. Can I ask everyone to make sure that mobile devices are switched off or on silent and put away, please? Agenda item 1 is declaration of interests. Before we begin, can I welcome Alison Harris and Maurice Golden to the committee, who join us to replace Oliver Mundell and Annie Wells. And can I just put on record the committee's thanks to Oliver and Annie for all their hard work and contribution during their time on our committee. Can I invite Alison Harris and Maurice Golden to declare any relevant interests that they might have? Alison.
Thank you, Convener. I don't believe I have any relevant interests that require declaring.
Thank you. Maurice.
Likewise.
Okay, thank you. Now, agenda item 2 is the Civil Partnership Scotland Bill. We're taking oral evidence today and have 2 panels. Can I welcome our first panel, Fiona Blair, President of the Association of Registrars Scotland, Rod Burns, Deputy Registrar General, National Record of Scotland, Fraser Sutherland, Chief Executive, Humanist Society Scotland, and Ephraim Borowski, Director of the Scottish Council of Jewish Communities. You're all very welcome this morning. Thanks for being with us. Can I start by asking you to tell us just briefly about your organisations and whether you support the general principles of the bill, please? I'll start with Fiona.
I am the President of the Association of Registrars of Scotland, also known as AROS. We've been representing Scottish Local Authority Registrars since 1865. AROS provides a valuable networking group for registrars and assistant registrars, and as an association we're very proactive in contributing towards a workable and customer-friendly registration system. We also work closely with the National Records of Scotland, and we provide professional advice on registration procedures and take part in working groups such as this. And we are in favour of opening up to mixed-sex civil partnerships.
Okay, thank you. Fraser.
Yeah, Humanist Society Scotland, we're the national body for humanists in Scotland. We have 15,000 members across the country, and obviously many people know us for providing ceremonies, weddings, funerals and naming ceremonies, and obviously we're very supportive of opening up the opportunity for civil partnerships as well to mixed-sex couples.
Thank you.
Good morning, I'm Ephraim Borowski. I'm the Director of the Scottish Council of Jewish Communities, SCOJEC. And we are an umbrella body for all the organised Jewish communities in Scotland, which are the ones in the cities, but we also work very closely with the scattered Jewish population of more remote areas. And we've just finished a piece of research, not looking at this kind of issue, but just looking in general at the issues that concern Jewish people in Scotland.
Okay. And do you support the general principles of the bill?
I think the other thing I should put on record is that there are some political issues with a small p where it's not really possible to speak with a single view on behalf of a diverse, ethnically and religiously diverse community like the Jewish community. So I'll be speaking probably for a kind of consensus, which is that we're unlikely to be very much engaged with this, but we don't have any objections to it. But individuals and groups within the community have got diverse views.
Okay, thank you. Rod.
Morning. National Records of Scotland is a non-ministerial department of Scottish Government, and we oversee the registration system. We provide support in terms of IT process, training, those kinds of things, in order to implement Scottish Government policy around registration, and we're in support.
Thank you. And can I ask what implications for your organisations you think the bill might have, if any?
We don't think there'll be many implications apart from the initial setup. As regard to forced civil partnership, that would be something that our social work departments would need to incorporate along with forced marriage. So that would be a change to their interagency guidance, and possibly training, releasing registrars to come down to Edinburgh to do centralised training and the associated travel costs. But apart from that, we can't think of anything that would impact on our service.
Okay, anybody else?
For us, it would be much the same as what Fiona touched on. It would just be updating the training and information that we provide to people. But given that many of our celebrants are already trained to provide civil partnerships for same-sex couples, then the procedures would be the same. It would just be updating them on what's available.
Okay. No,
I think
anybody has
there
any-
may well be 2 points at which there will be an effect for us. One is that we have a semi-official role through a concordat with NRS. If somebody wants to be married, a couple, let's say, one from Scotland and one from anywhere else in the world, and want to be married by a rabbi from back home, wherever it is, then NRS will require to check the bona fides of that individual, but they don't want, I think quite rightly, to get involved in the internal divisions between groups within the Jewish community. So they have a single one-stop shop, namely SCOJEC. They will come to us and ask us to go to the relevant branch of Judaism and check this individual out. So that will obviously apply to civil partnerships just as much as it does at the moment to marriage. The second and more important one is something I very much welcome, is the inclusion of Section 9 of the bill, which is about religious divorce. At the moment, the only listed faith is Judaism, but the same provision might be available for other faiths if they wanted it, which is why it's written in general terms. And that's extremely important because it mirrors the clause in the Divorce Act, which has been extremely useful and has really put an end to the abuse, as far as we're aware, that there used to be.
Thank you.
NRS adding in mixed-sex civil partnerships is simply adding a complementary new function. So obviously there are resource implications in terms of, as Fiona said, of the initial setup, making changes to Forward Electronic Register, which is the national electronic database for registration, the changes that needed to be made there, system changes, training of registrars, amending process, updating our handbook, all that kind of stuff. So there's there's resources that have to be devoted to getting the system set up. But once it's up and running, I think it'll just become part of business as usual. As I say, it's complementary to same-sex civil partnerships, which were long ago, I think Fiona would agree, have become a regular part of registration business and completely unproblematic.
Okay, thank you. Alison Harris.
Yes, good morning, panel. I would really like to ask you, just really, what are the differences between marriage, with civil partnerships, legally and socially? If you could just try and explain that further for me, please.
That is something that is quite confusing for the public. They're often asking us, what are the differences? My understanding is that adultery cannot be cited as a reason for dissolution of a civil partnership, whereas adultery can be cited in a divorce case. There's very little difference now between civil partnership and marriage with regards to, legal rights, because that has been sort of protected over time and changed. So I think that's quite confusing for the public and something I think that would be good if we had clear guidance on.
Yeah.
I won't speak too much on the legal side because you've got much more expert people than me here to do that side of it. I think socially, though, you've had quite a lot of written evidence from couples and individuals who see, still historical context of marriage as something that they don't want to enter into, and actually that civil partnership is more attractive to them just because of historically how marriage has been framed. It's interesting, though, that, with the introduction of same-sex marriage, that a lot of same-sex couples have chosen actually to get married rather than to continue to opt for civil partnerships, which when they have the choice of the two. And given that some of the historical issues have been about being discriminatory against LGBT people, for example, and the lack of ability to have a wedding, and that's now not an issue. That's perhaps changed some of the social aspect of marriage. Also, social aspect of marriage has changed dramatically over the 20th century. It used to be a religious thing, and then registration services on behalf of the government became the most popular choice. And then at the turn of the 20th century, humanist marriages are now a thing. After 2005, and it's a growing popular demand there as well, which is in the words of the Act, a belief marriage as opposed to a religion or a government-based service. So the landscape, if you like, socially of marriage has changed quite considerably, certainly over the whole of the 20th century. But even since that 2005 decision to allow for a belief body, and then in 2014 actually changed the law to recognise belief marriages.
Okay, thank you.
I think the difference for the Jewish community would be minimal, in fact, because the reason that we need Section 9, if I can start there, is that in the case of marriage, a single ceremony creates two marriages. It creates a civil marriage and a religious marriage. And therefore, if that's going to come to an end, they both need to be terminated and the processes are different. The reason why I said at the beginning that I didn't think this was actually going to have a lot of practical impact is that the reasons that people give for wanting civil partnerships rather than marriage would make it almost contradictory for them also to want to have a religious marriage ceremony. So it may be that this doesn't come about, but Judaism, in effect, recognises marriage by custom and repute, for want of a better phrase, in that publicly living together still requires a religious divorce. So from that point of view, I think if somebody were to go down the new path envisaged by the bill, it would make very little difference at all.
Okay, thank you.
I would say, principally, we work quite closely with Scottish Government to input when they're developing new policy on something like this. But we see ourselves quite squarely in the role of implementing whatever the policy ends up being, whatever the law ends up being. So essentially, I think NRS generally refrains from taking a view on the social impact of something, even though obviously people who work in NRS are quite interested in matters like marriage and civil partnership, and it's not as though we're not interested, but we are at the kind of receiving end of settled policy, and then we work quite carefully with registrars and Scottish Government and other stakeholders to make sure that we implement things in a fair and transparent way. So I'm just thinking of civil marriage introduced in 1940, civil partnerships, the introduction of belief, the category of belief marriages. They're all sort of staging posts along the way of new settled policy, and we work quite carefully to implement that. So I would say essentially we don't take a view on the social benefits of it, even though there clearly are social benefits. We just crack on with making a good, decent implementation job.
Thank you. Thank you.
Ms. Golden.
Thank you. Fiona Blair mentioned that one of the differences between marriage and civil partnerships was the grounds for divorce or dissolution, specifically around adultery, and I was wondering if the panel had any views on this specific aspect.
Views, I would never get involved in a divorce or dissolution aspect of marriage. That's something that would be dealt with legally.
I think there's a wider question around actually reviewing the whole of the divorce legislation and how it sits at the moment. I think there are a number of voices out there of people who don't feel that the divorce legislation is, up to date and modern in the way that life's work in terms of the separation requirements. And there's been some high-profile cases I know down south, but nevertheless, I think there's maybe a time for a review wholesale of that rather than necessarily just on that particular issue.
I think I'd agree with that. In Judaism, marriage is entered into voluntarily, and the contract is ended equally voluntarily by the parties. And therefore, pardon me, in a sense, it is the only ground for religious divorce is irretrievable breakdown. The parties say this marriage has come to an end. So I think anything that goes in the direction of that level playing field would be consistent with where we're coming from.
We don't have a view on that issue.
Fulton McGregor.
Thanks, Leader. Good morning, panel. I was going to ask you a wee bit about the benefits of introducing different sex civil partnerships, and to ask you what you think the impact might be in different equality groups. We've had some written submissions from, for example, in Gender, Children in Scotland, and others, just letting us know what they think the benefits might be. Have any of you got a view on that?
think it's really good from an equality point of view. It would become, it would give us parity with other areas of the United Kingdom, so that we could then recognise mixed-sex civil partnerships here in Scotland. They've already taken place in England, and we, as registrars, since it's been implemented down in England, we've had 47 inquiries over 11 local authorities. That was just a small sample that I took before I came. So I'm actually specifically asking for a mixed-sex civil partnership in Scotland, and the reasons that they're given are varying from there's their personal preference, they see marriage as a one-time thing and they want something different. They don't want to have a ceremony. With marriage, you must have a form of ceremony. With a civil partnership, you can do a registration. That they had previously been married and it had ended with a death, and they don't want to be married again because that was seen to be sort of like not honouring their first husband or first wife. So there's lots of different reasons that they're given for actually wanting to enter into a mixed-sex civil partnership, and I do think from an equality point of view it's a good thing.
From our point of view, just giving people the opportunity, the couples, to decide for themselves is really important. And given we have this mixed system at the moment, where some couples can enter into a civil, can choose between the two options, and some couples can't, is obviously not one that we would favour, and this bill obviously seeks to repair that. I think, you know, the people have pointed out, you know, Fiona's highlighted some of the cases there of why people might perhaps choose a civil partnership over a wedding, but at the heart of the matter, it is about giving that couple the choice and allowing them to decide, you know, what is it that's right for them, and they might have a myriad of different reasons for that, but I think it's quite important that we recognise their choice when they're forming that relationship in a legal context.
I can only really speak for one equality group. And beyond that, I think all I would say is that if other groups feel that it benefits them, our default position is to be in favour of equality.
Excuse me, I think there are clearly a range of benefits from having a wider range of excuse me, legal unions available to people. But I think there are some key specific groups who are going to benefit quite strongly. For instance, people who are undergoing the gender recognition process. It's always seemed quite harsh under the current rules, and NRS takes the end results of the UK Gender Recognition Panel, and we implement them and make an entry in the Gender Recognition Register. So we're sort of involved in the practical business end of changing people's birth certificates and kind of facilitating the official legal recognition of their new status. But somebody who's in an existing civil partnership would have to dissolve that prior to this coming into force. And that's always seemed quite harsh and rather against the equality, the general drift of equalities, I would say. So to me, that's one key benefit for, albeit a small number of people, but a key equalities group. But I would agree with the comments of all my other panel members as well.
Thanks very much for those responses. And just, I suppose, following on from that, do you as a panel think that there's, or what do you think are the specific benefits to civil partnership in comparison with cohabitation?
Well, I think it would give them better financial and legal, status. They would have a sort of recognised union or certificate that they could prove that they are, a couple, opposed to being cohabiting and having to prove that they've been together for a certain period of time. Apart from that, I can't think of anything else.
For humanists, we would obviously favour a system where it didn't actually matter what the legal status of your relationship was. That you should be treated in the eyes of the law, and that's where lawyers probably roll their eyes and go, "That's a nightmare. How would you even police that?" But we as a kind of belief body, if you like, for want of a better expression, would say actually the important thing in the relationship is the commitment between the people, and it doesn't really matter whether you have a piece of paper that says you're in a civil partnership or a marriage or you're cohabit or you don't have that. Actually, it's about the relationship at the heart of it, and it's the commitment to one another that's important rather than the fact that you've got a bit of paper.
Do you think, though, under the current, and I hear what you're saying about the sort of the idealist point of view, but in the current system, do you feel that it does provide more financial security?
Well, I think there will be more people who, there's people who have self-excluded themselves from the marriage landscape because they felt that they haven't fitted into that. So this gives them an option to access that kind of legal advantages, if you like, from civil partnership that they wouldn't get because they don't want to enter into marriage. So that can only be a good thing. I mean, we've had over the years a number of people who have wanted to enter into civil partnerships and haven't had that option. Now, some of these people, might change their mind and then decide they want to have a marriage instead. But some people decide that they don't want any, ceremony, or they don't want any legal ceremony anyway. And so then they've just continued to cohabit. So this is then going to be another option to them. And, Fiona's already highlighted that they've had a number of inquiries. And, since the legal changes down south, we've had people again get in touch and say, how long is it before I can have this as an option? So,
okay, thank you.
As I understand, there's very little practical legal difference between the two. So the reason that somebody might opt for civil partnership is, as Fiona says, that on the one hand, they want recognition, but on the other hand, they reject, and this is quite clear from the English court cases on the topic, they reject some of the baggage that comes with the term marriage. And if that was a reason for not formalising the relationship at all, then having this option, which allows them to get that recognition, that formalising it in a way that will then impact on children, property, and so forth, is obviously a good thing.
Excuse me, I would echo that stress on recognition, and with many apologies, Fraser, not wanting to publicly disagree. NRS is in the business of producing and standing behind bits of paper, so we think they're quite important, and they're only important, though. You're right, they're not any reflection of the strength of somebody's relationship, but they're the means by which people can rely on the formal legal recognition of their union. So, as I said earlier, we think that being able to expand the ways and the number of options people have to acquire that legal recognition is a good thing. I don't have any comments specifically on the underlying issue, though.
Angela Constance.
Thank you, Convener. Good morning to the panel. The bill replicates the existing provisions that exist for religious and belief bodies to opt in if they wish to register different sex civil partnerships. So I wondered what the panel's views on those provisions are, and I wonder if I could start with Mr. Borowski.
I thought you might. Obviously, this is, as it were, at the interface between NRS and the community, because I touched on this earlier, that if somebody, this will not be an issue for a couple, both of whom are Scots. If they're a member of the Jewish community, then whatever clergy their community has will automatically be recognised by NRS to solemnise marriages, and if they wish to solemnise civil partnerships. The problem that arises is purely a practical problem when one member of a couple is coming from elsewhere, including England, and therefore the celebrant has to be somehow certified to NRS for them to recognise the religious ceremony as creating a civil marriage or civil partnership. The new wrinkle in that will be that the different umbrella communities, the Orthodox community, the Reformed community, the Liberal community in Scotland, and potentially other branches of Judaism that don't actually exist in Scotland, but a member of a couple coming from elsewhere might want to bring their own celebrant from their own community back home. So the issue might be if the branch of Judaism doesn't recognise or doesn't wish to participate in civil partnership ceremonies of any kind, and then you run into, that's why we've suggested a couple of tweaks to the wording to handle the case where you might have an individual rabbi or member of the clergy who is prepared to carry them out, but belongs to a branch that has turned its face against them. And therefore, we would take the view that there have to be 2 checks and not just one, because if somebody is performing a religious ceremony, then they're doing it on behalf of their faith community, and therefore they can't dissent from the view of their faith community at the same time as supposedly representing them. So that's the thinking behind our suggested tweaks to the wording.
So can you summarise what you think the solution is, given that, and you can correct me if I'm making wrong assumptions, that I'm assuming that pluralism within the Jewish community is going to continue to exist. So, and you've made suggestions about the word, and I just wonder if, for the record, if you could kind of explain what would help.
And I think well, let's start with marriage again. At the moment, if somebody wants to bring their rabbi from Patagonia, NRS will ask us about the bona fides of this individual. We will check with whichever branch in the UK or in Scotland they purport to be affiliated with, whether they accept that they're affiliated, and we'll then pass the answer on to NRS. Now, the same would happen if it were civil partnership, as happens at the moment in the case of marriage, but what we are suggesting is that there would need to be 2 checks and not just one, that the individual is willing to conduct the ceremony. Presumably, they've already been asked, otherwise the couple wouldn't have suggested it, but also that the branch that they're claiming to be affiliated to has not got a policy which would prevent one of their local members from carrying out that ceremony. So it's just an extra check, which would in fact, I think, be carried out by us rather than by NRS, and we would then report to you.
Okay, thank you for that. Mr Sutherland, in terms of my root question, is there anything you would like to add?
There's nothing really specific. I mean, obviously, the bill will replicate the prescribed status that the organisation has under the existing legislation, which allows us to nominate celebrants in order to carry out humanist ceremonies. So there's nothing major that I would see would change in that when it comes to civil partnerships. It would be the same. We don't quite have the same issue that Ephraim pointed out. We do get quite a few. We get quite a lot of couples actually who come to Scotland in order specifically to access humanist marriage, because it's not something that's offered in many countries around the world. It's notably not available in England and Wales, which are the majority of couples of our sister organisation who are based down south. People who want a legal humanist marriage then choose to come to Scotland to enter into that because they can't have it in England and Wales. There are some other European states where it is recognised, and some US states, but we do still get quite a lot of people where Scotland is actually seen as a bit of a kind of destination wedding. There's a lot of, Fiona would be able to give you the statistics on this, but there's a lot of couples who choose to come to Scotland to get married for a variety of reasons. And for us, we're only a small part of that in terms of the belief marriage, but it is something that is important. And obviously, given that this is an option now for more couples, that might drive extra people to come to Scotland. It might not. Certainly won't from England and Wales, but it might from further afield where maybe civil partnerships for mixed-sex couples aren't available.
Okay, thank you, Mr Sutherland. Is there anything other members of the panel want to add? I know neither Ms Blair or Mr Burns are here representing religious or belief bodies, but given what you've heard, there might be something you wish to add.
Yes, I'd just like to add that I think the opt-in principle is very, very important. And we did a bit of research, as did Fiona, excuse me, around how many bodies so far with existing civil partnerships have opted in to do them. And it's only 13 religious and belief bodies, according to our records, who've actually opted into the list to do that. So there's, whereas there are quite a number more religious bodies and belief bodies in Scotland that do, for instance, opposite sex marriage, or, there's, I think it would be dangerous to presume that everybody who puts forward celebrants for authorisation automatically wants to do this. And I would say, I would chime with what Tifrim said in terms of it isn't just the body, but it's also the individual celebrants. There shouldn't be any kind of compulsion against any kind of compulsion for a body to provide celebrants to do this, or for celebrants individually to do it. And I think that principle of voluntary engagement with this has worked very well so far with existing civil partnerships. So our general principle would be, if it's working well for same-sex civil partnerships, we should probably replicate that kind of process for mixed-sex civil partnerships, given that it's tried and tested already.
Okay, thank you.
I think civil partnerships, up until 2014, were civil. They were carried out by a registrar and assistant registrar, and then it was opened up to, under the Marriage Act of 2014, Civil Partnership Act of 2014, to religious and belief groups. I think there has only been, looking at statistics, 9 actual civil partnerships that have been conducted by a religious or a belief body, with the majority being still civil with a registrar or an assistant registrar. So I don't know whether the word civil, people associate that with registration services, but I think it's good to give people choice, across the board. So that would be my view.
Okay, thank you. Thank you.
Okay. Alex, go on.
Thank you. Good morning to the panel. Thank you for your remarks so far. They've been very interesting. It's clear to the committee from the start of this bill that one of the drivers behind extending civil partnerships to mixed-sex couples is the not inconsiderable baggage that some people attach to the term marriage or the institution of marriage, and that people find it, for many reasons, off-putting, and they don't want to go down that route. And in fact, Fiona Blair, you articulated very well, I think, a reason I hadn't heard of before, which is perhaps in the case of widowhood, where somebody would want to honour the marriage that had gone before, but solemnise the relationship that they're now currently in, and I think that's exactly right. Section 3 of the bill talks about interim recognition of different sex relationships formed out with Scotland. So in jurisdictions where we already have mixed sex civil partnerships, and that's happening in England right now, so couples who have that civil partnership come to Scotland, and until this bill is adopted and implemented, Section 2A Part 2A of Section 3 suggests that we will treat them as being in a marriage in Scotland. Now, that came out quite strongly last week, that was going to be a real concern for people, because we've just discussed that that's not what they got into, and they don't want to be thought of as being in a marriage. Can we have your views on that? And do you see any sort of way around that, way in which the implementation of this bill, we might regard it differently?
I can't say I've actually thought about that. At the present time, registrars would not recognise a mixed-sex civil partnership in Scotland, but I don't really have any strong views about I think the interim part, recognising as a marriage, is quite difficult for people, because they entered a civil partnership because that was their choice. They didn't want a marriage. They had the choice of marriage or civil partnership, and they went down that route. So I can see how people would be, not happy about that, but I really don't have a view as a registrar, I'm afraid.
I suppose this comes down to a bit of a kind of the legalities of it, really, isn't it? And how you can recognise something that doesn't exist, I imagine, is why it's drafted that way. I genuinely agree with your, the principle of what you're putting forward, that people have deliberately chosen not to have a marriage, so why are they then classified as that? But I suppose, the drafters would say it's because they want to provide the protection that comes with that, because they are in a legally recognised relationship. So it's a tricky one to square, with no doubt.
Anybody else?
I don't really have very much to say about this, but nonetheless I will, because I can't help it. Given that there's almost no difference between the two states, I think I would make a kind of logic chopping point that there's a difference between being married and being treated as being married. And this interim status is merely being treated as if they were married because there's no alternative to that at the moment. And you can call it what you like. It's merely a recognition of something that happened somewhere else. And the analogy, I think, if I remember correctly, somebody discussed this with you on Monday, the analogy with polygamous marriages. You can't have them here, but if you're misguided enough to have one somewhere else, then you're treated as being married to all the people that you're married to. And there would be a similar kind of thing to that. It's treated as if it's not the same as actually having that status.
That's a very helpful insight, actually, and actually, reading it in that context does put a slightly different spin on it. By extension, then, because we have such an institution as a civil partnership in Scotland, albeit through same-sex couples, why can we not, what impediment do you see to us changing this clause to say that they will be treated as being in a civil partnership? I know that the institution of civil partnership for mixed-sex couples does not yet exist, but we can treat people as if they were in a civil partnership because the institution does exist. Perhaps, Mr.
I take it you're asking me again.
Yeah, no, I think because you offered the insight, I'd be quite interested to hear your view on that particular point.
I think I would give you the same answer. This is turning into a bit of a philosophy tutorial. I'd give you exactly the same answer if it had been the other way around, that treating somebody as if they were in a civil partnership is not actually creating civil partnerships. So from that point of view, I'm not sure that I can see any difference. And if that people would be happier with that tweak, it doesn't affect us. Now I'm not speaking as a representative of the Jewish community, I'm just engaging in an interesting discussion. I can't see a problem with it.
Yeah, could I add that there are a few practical implications of not having any form of recognition for the period within which this bill might not be adopted. Say, for instance, a couple who's in a mixed-sex civil partnership in England and Wales, wherever it is, Northern Ireland, comes to Scotland, sets up home, gets on with their job, they're busy engaging with life. One partner becomes pregnant, they give birth. If you don't have any civil status, certain things like parental rights flow from being treated as married. I think that is a key distinction, albeit you're not married. And I take the point that people take their civil status very seriously. It touches on their personal identity, certainly in terms of civil partnerships, I think. In the past, people are quite keen to keep us on the front foot and to keep us very, very almost punctiliously right in terms of terminology and the way that the language we use as registrars and people who oversee registration treats them properly and respectfully. So I absolutely take the point that being classified or treated as married when you are not married and you don't like all of that baggage, it's a real thing. It's not just a cavil, it impinges on people's identity. But equally, if there was no protection in that interim period, there would have to be fairly extraordinary measures taken to make sure that somebody, for instance, could be treated as the father of a child and all of the legal responsibilities and rights that flow from that through marriage, whereas treating somebody as married, albeit it would, I guess, be offensive to their identity, would mean that they would have a much less problematic route through to receiving parental rights and responsibilities and all of the different benefits that flow from that socially and legally. And I think the practical terms also, different forms of civil state. When people die, people have to serve as informants. There's a whole host of information and background data that we collect, some of which goes onto register pages, which is defined by your civil status. So I think practically speaking, albeit it isn't ideal probably in terms of people's identity, having some form of recognition is better than having no form of recognition. And certainly we deal with quite complicated cases every day, as do the registrars. that take a lot of delving into and a lot of untangling when certain of these situations occur. So I would say, from an administrative viewpoint, if nothing else, putting in place some recognition that forestalls those sorts of complexities can only be a good thing, and it's temporary.
Yeah.
And I think most reasonable people would probably say, well, I don't like it, but I can see the benefits both to me and to the state more widely.
Thank you, Rod Burns. I accept all of that. And I think it's important we do have some recognition in the interim. However, from an NRS perspective, can you see a legal impediment to us changing that clause to, instead of the word marriage, insert the word civil partnership? So it's being treated as a civil partnership, an institution which exists already in this country with all the trappings that you describe, albeit not for mixed-sex couples. We're just treating it in the same way. Is there any problem in us amending that you can see from a legal perspective?
Well, I'm not qualified to comment from a legal perspective, and actually I'm feeling a bit like one of Ephraim's philosophy students, because the only way I could see would be that this bill had already been passed and that we already recognise mixed-sex civil partnerships in order for that to take place. I mean, my brain is sort of falling apart trying to understand that.
But we don't need to already recognise mixed-sex civil partnerships for this to work, because there is an institution called civil partnership. It confers all the parenting rights, it confers all the sort of pension stuff, everything around it. But it is incredibly important to people who do not wish to be seen as in an institution of marriage or treated as if they were in a marriage. Just that I think the nomenclature around this is incredibly important, and it, as you say, touches to people's personal identity. We've been asked to change it. I'm just wondering if we can.
Honestly, I don't know, other than it's defined exclusively as for same-sex partners at the minute, which is the philosophical hurdle I'm trying to get over. I guess maybe with your session next week with the Minister and legal reps, they can come up with some wizardry that would answer your question. Hopefully so.
Taking the words out of my mouth there, I think these are questions that we will explore further with the government. Are you content for now? Okay.
Thank you for the philosophy. Appreciate it.
Mary Fee.
Thank you, Convener, and good morning, panel. Mr Burns, you briefly touched on the issue of gender when you answered a question from one of my colleagues, and that's the issue I want to explore a bit further. In our evidence session last week, Professor Norrie suggested that the provisions regarding gender recognition are overly complex, and I wonder if, and I'll start with Mr Burns, if you share that view, and if you don't, if you could explain why you don't, and if you do, if you could explain why you do, and then I'll come on to the other panel members. Yeah,
I haven't actually read Professor Norrie's testimony in full. Could you just give me a quick capsule of why he said they were overly complex?
Professor Norrie said in his written submission, and I'll cover that first, he questioned whether the full implications have been worked out when one party to an existing civil partnership or marriage changes gender. And one of his reasons for saying it overly complicates things, his view is that the issue of gender recognition should be dealt with in the Gender Recognition Act, and it shouldn't be brought into this piece of legislation. Because currently, someone in a same-sex civil partnership who's seeking to obtain a gender recognition certificate would need to end the civil partnership. If different sex civil partnerships are introduced, a couple in a civil partnership and where one person seeks to change gender could continue that civil partnership if the other person agrees. And his view was that we're making things more complicated than we need to be, and we need to do something when we're looking at the gender recognition legislation at some point in the future. That's the appropriate place to do something about gender.
I mean, obviously, Scottish Government's consulting on gender recognition reform at the minute, and from my engagement, both with officials in Scottish Government and other stakeholders, is that is a ferociously complex area and far from uncontroversial. And we try, in NRS at least, to stay away from controversy if at all possible, and that would just return back to our kind of key purpose that I mentioned at the beginning, which is that we do work quite closely with Scottish Government policy colleagues to work out, to try to serve actually as a springboard for some of the practical implications of what a proposed avenue for policies might be, in terms of thinking through what our processes are, how the policy is fully worked out, you know, in terms of the sort of information we require, the data that goes onto forms, and it spirals quite quickly into complex discussions. But as far as I'm concerned, at least, one of the key benefits of what's proposed here, and it does seem to me, I'm not going to argue with Professor Norrie, but it seems a relatively limited proposal with fairly huge implications, benefits for that individual who's wanting to undergo gender recognition. And it was just one of the things that stood out to me personally, because we do deal with, as I said, relatively few numbers, maybe 25, 30 people a year in Scotland who have gone through the gender recognition process and been awarded a full certificate. We then receive all of that package of information from the UK panel and set about kind of essentially putting their life on a new footing. And it is quite moving talking to people who've gone through that process. You know, there are not many people who do it, but it's absolutely profound, the impact, and it does touch very deeply on identity. So, from my view at least, and it's obviously, it's just my personal view, the benefit you could get from a relatively limited engagement on that issue, on the gender recognition issue, would be quite profound. Obviously, the complexities of dealing with gender recognition in the round are enormous, and not least in terms of NRS and the registrars. They've got quite significant implications for additional workload and resources that we'll need to put in place if we were to go down the route of having a self-certifying process and sort of pulling out of a tribunal context. But I think my view would be probably those things are so complicated that we probably don't have time to get into them now. Obviously, that will happen in future. But I would still reiterate, as things stand here, it seems to me that it's relatively limited, but it has quite significant benefits personally for the individuals.
Yeah, and it would be fair to point out at this stage that a number of different organisations welcomed the approach that's been taken in this piece of legislation in relation to gender. Professor Norrie had a different view from a number of different organisations. Do any of the other panel members have a view on this?
Just echo what Rod has said. Gender recognition would be dealt with at NRS and not at registration levels.
Okay.
I think for us, I mean, it's about ensuring that the system allows a couple who consent and want to remain in that relationship. I mean, my understanding is if this isn't in it, then the people would have to legally separate and then reform the relationship in a legal sense. Whereas if both parties are accepting of that happening, I don't see why that's beneficial to stop that happening.
Okay.
I don't think I would want to say anything on behalf of the Jewish community about this one, because there will be diverse views both about gender recognition and about civil partnership, and the interface, the interlocking of the two is going to produce just so many different possible answers that I couldn't possibly speak on that without doing an awful lot of homework. But I would make the point that I think there's a clear link between Mary Fee's point and Alex Cole-Hamilton's point, because the status already exists, and therefore a sideways move is easier than dropping out and then coming back in, and then essentially going around two sides of the triangle rather than going straight across the base. So I think there is a link between those 2 points.
No, that's very helpful. Thank you.
Okay. Panel, we've had quite a bit of reflection on the sort of status of marriage versus civil partnerships and baggage or whatever that comes with it. Just to continue that a little further, can I ask for your reflections on whether we should allow married couples to convert to civil partnerships? Do you have a view on that?
I think because you can convert a civil partnership to a marriage, that will be a question the registrars are asked. I don't have any specific view on it. I know that the Scottish Government are not intending to have that as part of this bill, but may look at it at a later date. But I do think it's something we will be asked for.
Yeah, I mean, I think some of the couples who have come to us in the past and then decided that they wanted to proceed and have a marriage because a civil partnership wasn't available to them. Now, I don't know how they feel about that so many years down the line, if they would want to now convert or not. But it does seem odd that if we change the law and then that's a thing that's available to them, if there's no conversion option, the only way for them to get that is to get divorced and then reform a civil partnership, which I don't think is a good idea. So I would support, you know, the transfer provisions, because, like I say, there have been couples who have come to us in the past and they've said, I would like to have a civil partnership because of all the baggage reasons. Some of them then decide they don't have any, you know, legal relationship, but some of them decide they want to enter into marriage because they want to have the legal protections. And if we don't have the conversion option there, then those people kind of miss out just because they got married 5 years ago.
Anybody else?
I don't think we have a particular view on the pros and cons of it. I don't think it will make very much practical difference. Without consulting, this is kind of doubly hypothetical, but I don't think that if it were to be introduced, there would be any branch of the Jewish faith that would ask people to divorce first and then enter a civil partnership. If they simply wanted to change their civil status, that would be up to them, and it would, I think, have no particular repercussions further down the line, because the whole point, for example, of Clause 9, Section 9 of the bill, is to replicate what is already provided for in the case of divorce after a marriage. So it really would make no difference at all, I think, from our point of view.
Thank you.
Mine's just a straightforward, pragmatic view. If Parliament decides that marriages should be able to be changed into existing marriages, changed into civil partnerships, we will work with Scottish Government to figure out ways to implement that. And it's that simple, really, from our perspective. We don't have a kind of principled policy view on it. It's very much a pragmatic matter.
Okay, thank you. Who am I going to next? Mary Fee, we're back to you again.
Thank you. Thank you. I wonder if the panel, excuse me, I wonder if the panel had any views on how popular different sex civil partnerships may be. Because the government, in their preparatory work, they estimated there could be between 100 and 150, and they based their kind of cost analysis on 109. The Equality Network has estimated there could be 500 a year, and that's higher if you base it on UK government estimates. That would take it to between 2 and 8,000. So do the panel have any views on how popular this will be?
I think if you look at the statistics, I think if you look at the statistics that when same-sex marriage was introduced, basically civil partnerships dropped away down to about roughly 70 a year, and marriages increased because civil partnerships, people who were entering into them same-sex civil partnerships, they wanted a marriage. They wanted something that was compared, most of them, not all of them, but most of them wanted to have a formal ceremony, akin to a marriage. So I think you'll probably find that there'll be a redress. There will be people who will enter into, that have been cohabiting and just want that legal protection. I definitely agree that there will be a bit more. But as I said before, out of 11 local authorities, we've had 47 inquiries. So I think that there will be more people will choose that route. And whether that's a ceremonial route with a religious belief, or whether that's just a simple come into the registration office and do a registration, or whether it's a ceremony with a registrar, I can't say what the differences would be in numbers with that. But I definitely think the people will choose that, have that as an option, and they will choose that option.
Okay.
Could I just add to...
Sorry.
Oh, sorry. Yeah, could I just add to what Fiona says? She's right. I think it was the figures on the introduction of same-sex marriage went from something like 600 civil partnerships a year down to about 60 or 70. So a 90% drop-off, most of whom took up same-sex marriage. But by that same token, that means, and ongoingly, I think 50 or 60 new civil partnerships continue to be created every year. So there is a smaller but real demand for civil partnerships. So I suspect, that's quite a range, isn't it? From 100 or so, 150 up to 8,000. Yeah. Probably the truth is somewhere in the middle. I mean, I would say for the registrars and NRS in terms of overseeing the registration service, even at the highest end of that, 8,000 I think is probably unlikely, but somewhere between, there may be additional resources drawn down to do that, but we will adopt that into our normal business as usual. I think if we were looking into tens of thousands of cases, you would probably be displacing some of the available resources that registrars have, for instance, to do marriage. I mean, there are, I think last year, 27,000 marriages.
Yeah.
So the system is already knocking on for 30,000 civil unions, if you like. So I think we've got capacity to deal with quite a lot, but possibly not an additional 8,000.
Yeah.
But I hadn't heard that figure. That seems quite large, certainly compared to 100 to 150.
Yes, it's a massive increase. But do you think when the legislation, if the legislation is introduced, there'll be almost a kind of a spike? People will want this type of formal relationship, and then that might drop off and things will stabilise.
Yeah, that seems to be a fairly settled view, doesn't it? And certainly the experience of other countries suggests that there's that pent-up demand. There's a bump at the beginning, and then it tapers off down to maybe on that model, maybe a few hundred each year seems reasonable. No. And that would be something, certainly from a registration system perspective, if it was 200, 300, 400 a year, that's eminently absorbable into our normal business.
Okay. Do other panel members have a view?
I don't necessarily agree with Rod's last point there, although I appreciate that that's based on what's happened elsewhere. I mean, if I draw the comparison with humanist marriage and the position where in 2005 it was less than 100 people decided that was the option they wanted to go to now it's somewhere in the region of 5,000. Now the reason that growth is because people have gone to ceremonies and they've seen that and they want that replicated. So there is a kind of social growth, if you like, that's by going to it and seeing, and then they recognise that as an option. I don't know if that's going to happen with civil partnership. I mean, I don't have a humanist, I don't believe in crystal balls telling me the future. But so I can't tell you whether that's going to happen. But it happened with us for humanist marriage. Could that happen with civil partnerships? That as people start going to see civil partnership ceremonies, they actually feel that that's much more reflective of the type of relationship that they want to form. And that's the kind of question that probably is best for younger generations who are actually going to be entering into those relationships in 10, 20 years down the line. We can second guess what people now in the here and today would do, but we don't really know what the future might hold.
Okay, thank you. Mr. Borowski.
I think perhaps I could link this with something that Fraser said earlier on about marriage tourism. I don't see there being a huge uptake within the Jewish community in Scotland, but that leads me to correct something I said right at the beginning of this session when I was talking about couples, one of whom comes from outside Scotland. Actually, we should also be thinking about couples, both of whom come from outside Scotland, because the main difference between Scottish marriage, civil partnership as well, and English is that we license individuals, which is why we have the relationship that we have with NRS, whereas they license premises. So if a couple, for whatever reason, decide that they want to get married at the top of Ben Nevis, they can. And if they want to have a civil partnership at the top of Ben Nevis, they can as well. And given that they probably can't have a civil partnership back home, if they have emotional or philosophical reasons for wanting a civil partnership rather than a marriage, then Scotland's a very nice place, not necessarily at this time of year, to do it.
Not at the top of Ben Nevis, no.
So it may very well be that small faith communities will actually see that kind of marriage tourism that Fraser was talking about earlier as well.
That's an interesting point. Thank you. Yeah, thank you.
Committee members content? Yep. Okay, well, thank you very much for your interesting evidence this morning. It's been very helpful. We will suspend now briefly for 5 minutes or so. Welcome back to our second panel of the day. Can I welcome Tim Hopkins, Director, Equality Network, Kenny Stewart, Head of Policy, Equalities and Human Rights Commission, and Elena Soper, Programmes Coordinator, YWCA Scotland, the Young Women's Movement. You're all very welcome this morning. Can I start by asking you to just tell us a bit about your organisation, whether you support the general principles of the bill and what implications, if any, it will have for your organisation? I'll come to Elena first, please.
Yes, we support the bill at YWCA Scotland. We are a feminist organisation and we run empowerment programmes for not just young women but women of all ages through our national work based in Edinburgh and kind of community outreach work in Glasgow. And we don't foresee any issues if this bill was to go ahead.
Thank you. Kenny.
My name is Kenny Stewart. We at the Equality and Human Rights Commission are Great Britain's national equality body and one of the UK's 3 national human rights organisations. Our job is to help make Scotland, England and Wales fairer, which we do by safeguarding and enforcing the laws that protect people's rights to fairness, to dignity and respect. We do support the aims of the bill, and this is on the basis that this advances equality of opportunity for mixed-sex couples.
Okay, thank you. Tim.
Thank you. So the Equality Network is a national LGBTI equality organisation in Scotland. And all of our policy work is based on consulting with LGBTI people across Scotland. We first did that about partnership recognition in 2000 and 2001. And even right back then, people were saying to us the same things that they're saying now, which is a lot of LGBT people were saying the only thing that's true equality is equal marriage. We want to be able to marry. But a significant minority was saying, well, marriage is not for us. We would like to do something else. We would like to be able to register a partnership, a civil partnership. Civil partnership didn't exist in those days in this country. So our policy since 2001 has been that civil partnership should be introduced and should be available to all couples regardless of gender, but also that marriage should be equalised. And obviously it's taken quite a while to get to this point. Marriage was equalised 5 or 6 years ago. We consider this bill to be unfinished business from the equalisation of marriage. We very much welcome it. We think the bill is well drafted. We have one particular suggestion for something that could be added to the bill, but perhaps I'll say something about that later.
Okay, thank you very much. Alison.
Good morning, panel. I would just really like to ask you about the differences between marriage, civil partnerships, and what your views are, the differences legally and socially.
Shall I start off at this end? As the committee have already heard from other people, the legal differences between marriage and civil partnership are very small. Adultery is mentioned earlier on as one of the ways you prove irretrievable breakdown of marriage, but not for civil partnership. I could say some more about that later, perhaps. There are some other very small differences. There's a marriage is voidable, that is, it can be annulled on the grounds of permanent and incurable impotency of one person. That doesn't apply to civil partnership either. The Scottish Government described that rule as antiquated, I think, in the policy memorandum to the bill. The legal differences are tiny. The important thing is not about legal difference, it's about cultural difference, it's about social meanings, it's about personal meanings to the couple and to their family. I mean, the whole reason we supported equal marriage was that you could already get the legal rights through civil partnership, but that's not the same as marriage. Marriage has meanings to people that civil partnership doesn't have. And for many people, marriage is seen as the gold standard. That's why it was so important that marriage should be available to same-sex couples. But not everybody sees it that way. And for some people, as the committee's already heard, marriage is not what they want for all sorts of reasons, but they do want the opportunity to enter something like a civil partnership. Again, because the social meanings are different, the meanings for themselves, the meanings for their family are different. So the differences are not about the law, they're wider than that, and that's why this bill is so welcome.
Okay. Thank you.
Looking at this kind of from this feminist women's perspective, for some people, particularly women, marriage can be seen as rooted in kind of these patriarchal and outdated ideals, or perhaps closely bound in religious processes. And despite, the evolution of marriage, it's not the same as it was historically. It was only 30 years ago that rape was made illegal in marriage. That is still within living memory. So despite this kind of evolution to perhaps for it to be more equal, the anachronisms kind of on this can still be seen. I mean, even if you look at kind of the traditional wedding ceremony, the bride is still given away by her father to the groom. Civil partnerships kind of provide this alternative which can be perceived as a more equal commitment and less encumbered with kind of traditional societal expectations of women in their role as a wife.
Okay, thank you.
I don't have a great deal to add to those answers. Civil partnership is another route to what are very similar legal protections, and we absolutely understand why some couples may prefer that particular route for the reasons that my fellow witnesses have outlined.
Okay, thank you.
Maurice.
Tim and anyone else that would like to chip in, I wonder if you could just elaborate a little bit on your earlier point regarding the difference between the breakup of a marriage and the dissolution of a civil partnership, and what your thoughts are on that.
Yes, so the basic ground for getting a divorce or dissolving a civil partnership is irretrievable breakdown of the relationship. And the law says you can demonstrate that or prove it in a number of different ways. The principal ways are by ending your cohabitation. So non-cohabitation for 2 years is a ground for divorce, even if your partner doesn't want the divorce. And non-cohabitation for 1 year is enough for divorce if you both agree to the divorce. The other ground is what's often called unreasonable behaviour, which is where one partner behaves in such a way that the other partner can't reasonably be expected to continue to cohabit with them. And an obvious example there is domestic abuse, for example. Now, for marriage alone, but not civil partnership, the other way you can prove irretrievable breakdown is through adultery. But adultery has a very narrow definition. It means sexual intercourse between a man and a woman, where one of them is in the marriage and the other one isn't. Other forms of sexual infidelity are not adultery. So if, for example, the husband in a mixed-sex marriage engages in sexual activity with another woman, oral sex, for example, that's not adultery. But his wife could still get a divorce on the unreasonable behaviour ground, not the adultery ground. So I think a lot of lawyers would say that the adultery ground is not really needed because unreasonable behaviour covers it all. When civil partnership was introduced 15 years or so ago now, we were quite happy with adultery being omitted from the grounds for dissolution, although we wanted civil partnership to replicate marriage law as much as possible. The reason we were happy with it is you can do it anyway under unreasonable behaviour. The reason, as I understand it, that adultery is still in the law of marriage in Scotland is that some religious bodies, like churches, it's important to them because adultery is mentioned in the Bible and so on. So it's been retained within divorce law for marriage, but we see no reason for needing it in civil partnership dissolution law.
That was really helpful. Thanks.
Fulton McGregor.
Convener, and good morning, panel. I was wanting to ask about the benefits of introducing different sex civil partnerships, and I know, Eleanor, that you began to touch on that in answering your last question, but I wonder if you could speak about the benefits or other impacts this legislation could have on the groups that you are here representing, or more wider, if you wish.
Yeah, so I've spoken already about, why for some women marriage isn't kind of an option for them. So currently when different sex couples who decide that they don't want to get married, they only have access to a degree of legal protection and social recognition offered by cohabitation under the Family Law Scotland Act. But they have fewer rights and responsibilities than they would otherwise be afforded through either a marriage or civil partnership. And so when we're looking at this, we know that women have less access to resources, assets and income due to systemic issues such as unpaid caring roles, the gender pay gap, violence against women, domestic abuse, and unequal representation. So these lesser protections when it comes to cohabitation are more likely to negatively impact on their rights and security. And just kind of as a side note, when we're looking at cohabitation, we know that the Scottish Law Commission is currently investigating whether this law relating to cohabitation is in need of reform and whether it's comprehensive enough to offer sufficient protection and clarity to couples. So couples that want to have these enhanced legal rights without entering into the institution of marriage really ought to have this kind of other option of entering into a civil partnership. And we believe that this would kind of benefit children and also any dependent children. And we just want to kind of make a point here that as an intersectional feminist organisation, you know, we don't only represent kind of straight women. So we want to highlight the positive impact that we see for our siblings in the trans and non-binary community, which I'm sure is something that Tim will pick up on, but who currently rely on the sex marker on their birth certificate, which may not be true of their lived sex, to determine what options of commitment are available to them. The extension of rights, we believe, would mean that trans people who've entered into a civil partnership prior to obtaining a gender recognition certificate wouldn't have to choose between their civil partnership and the GRC.
Absolutely. I mean, we agree the impact of the lack of legal rights for unmarried cohabiting partners is deeply gendered. And therefore, the extension of this provision to mixed-sex couples will benefit women in couples that have chosen not to get married for whatever particular reason that might be. Equally, as Elena also noted, we think that there is a benefit for trans people who will no longer need to end their civil partnerships in order to change their legal sex. We think that there's also a positive impact on civil partners from outside of Scotland, in that there can therefore be recognition, should the bill go through, of their relationship here. And I think that's all I have to say on that moment.
Speaking specifically about LGBT people, as has already been mentioned, the bill benefits trans people because anybody who's trans in a civil partnership who wants to obtain gender recognition has to end the civil partnership first, either by dissolving it or by changing it to a marriage. And obviously they have chosen not to change it to a marriage already, so they really don't want to do that. So that's a benefit for trans people. Eleanor mentioned non-binary people, and it's worth mentioning something that already applies in the case of marriage, where we have gender-neutral equal marriage. And that is that if you're non-binary, NRS operate a system in Scotland whereby you can marry without specifying on your marriage notice whether you're male or female. Because if you're being married by a civil registrar, for example, they provide a full service for couples, same-sex couples and mixed-sex couples. It doesn't matter whether you're male or female and whether the other partner is male or female if you're being married by a civil registrar. So you are allowed, in fact, to submit your marriage notices without specifying a gender, so long as you're being married by a civil registrar who would marry couples of any gender mix. And that's a benefit to non-binary people because they don't have to state on their marriage notices either male or female, which they're not. And the same would apply to civil partnership once it has become gender neutral or equal. I also want to mention very briefly young people, because obviously the lower age limit for marriage and for civil partnership in Scotland is 16. You don't need your parents' permission, unlike England and Wales. So there are very small numbers of young people do marry or enter civil partnerships, but some do. And one of the points that LGBT youth found in their consultation with young LGBT people is that young people are worried at the moment that if they enter a civil partnership, then just stating that they're in a civil partnership will out them as being lesbian, gay or bisexual because they're in a same-sex relationship, because civil partnerships are all same-sex at the moment. So those young people are welcoming the extension to equal civil partnership, because being in a civil partnership, stating you're in a civil partnership, will no longer out you as being in a same-sex relationship.
Thanks very much. And I think a follow-up question to that I think you've all touched on in your previous answers, but just to give you all the further opportunity to let us know if you think there's any other specific benefits to civil partnership in comparison to cohabitation. If you feel that you've already covered it, I'm okay with that as well.
True, as Eleanor said, that cohabitation law at the moment gives weaker protections to, in particular, financial protections if the couple split up or when one of them dies. Weaker protections than marriage or civil partnership do. The protections are weaker and they're less certain because you have to persuade the court that you were actually cohabiting, whereas if you're married or in a civil partnership, you have a certificate and that gives you the status there and then. As Ellen mentioned, the Scottish Law Commission are reviewing the law on cohabitation. I believe they published their discussion paper on this yesterday. So we might see improvements to the law on cohabitation, but it may very well be that people feel that because you make a positive choice to opt into marriage and civil partnership, that the protections there should perhaps, especially in finances, be stronger than they are for people who've made a choice not to sign up to those things. But that's something that will come out in the discussion around how the law on cohabitation should improve.
No, I don't have anything to add to that. I think, yeah.
Thanks very much, Commissioner.
Thank you, Convener, and good morning to the panel. The bill, as you know, replicates the existing provisions with respect to how religious and belief bodies might want to opt in to register different sex civil partnerships. So I just wondered what the panel's view on those provisions are, and given Mr Stewart's role as a human rights guarantor, I would like to start with him.
As you say, the bill replicates the provisions in the 2004 Act, and we think that the existing exemptions in the Equality Act 2010, which allow religious or belief bodies to refuse to undertake same-sex marriages, would ensure that a religious or belief body that decides not to undertake civil partnerships in general would therefore not be discriminating on the grounds of sex or sexual orientation because they're not providing that service to anyone.
Yeah. Okay. Other members of the panel?
Yeah, we certainly welcome that religious and belief bodies will be able to opt in if they wish to conduct mixed-sex civil partnerships. The Humanist Society of Scotland obviously have already said that they'll do that. I believe the Unitarians have said something similar. They conduct same-sex civil partnerships at the moment, so we welcome that. Just to come back on a point that Kenny made, it's true that equality law at the moment has exemptions, which mean that religious and belief bodies are not under any obligation to conduct either same-sex marriages or same-sex civil partnerships, and we agree with those exemptions. I actually think something needs to be added to the Equality Act, and I believe the Scottish Government are going to ask the UK Government to do that in the Section 104 order that makes consequential reserved legislation amendments consequential to this bill. And that is that I think there might be a situation where a religious body would be willing to register mixed-sex civil partnerships, but not same-sex civil partnerships. Have I got that the right? No. I've got that the wrong way around.
Yes.
They would be willing to register same-sex civil partnerships, but not mixed-sex civil partnerships, because they may well view that if you're a mixed-sex couple, you should get married, but they may disagree with same-sex marriage and nevertheless be prepared to register same-sex civil partnerships. So we think that the Equality Act may need to be tweaked to protect religious and belief bodies from claims of discrimination if they do it that way round. If they say, we'll register same-sex civil partnerships, but we won't register mixed-sex civil partnerships. And that, I think, needs a small addition to the Equality Act.
Okay, thank you. That might be something we'll pick up with the Minister next week. Thank you.
Okay, thanks. Alex Go-Hamilton.
Thank you very much, Convener. Good morning to the panel. Sorry, did you want to come in, Helen? Okay, great. I think you each represent organisations who, more than most, have particular views about the institution of marriage and the baggage that it can attach to the people that you represent through your organisations. I think you've, Eleanor Soper, I think, articulated very well in terms of the gendered hang-ups that marriage still has attached to it, and it's a welcome reminder that there are some aspects of the institution of marriage and the ceremonies, even in civil services, which many might find arcane. I'd like to ask the same question of this panel as I did in the previous panel, that the interim measures provided for in the Act before the introduction of mixed-sex civil partnerships becomes real in Scotland, that the recognition of those mixed-sex civil partnerships entered into overseas or in other parts of the United Kingdom where they already happen will be treated as quote-unquote marriage in Scotland. Do you feel that that attaches a level of baggage unnecessarily by almost pretending that these people are in an institution that they have demonstrably rejected?
Yes, I do agree. We know that not only in England and Wales, who introduced it last year, and I have to say it's quite odd. I feel like it's been a long time since a progressive policy was introduced in England and Wales before it was introduced in Scotland. But also in France, which has had the Pacte Civil de Solidarité, which is the civil partnership, has had that since 1999. And, you know, commitment is an inherently personal choice. You know, even if you are a hardcore feminist, it might still be that you want to get married, and it shouldn't be up to the law to determine what kind of commitment is right for them. There should be kind of an open thing for everyone, and for someone who, for whatever reason, whether it's religious, whether it's moral, ethical, perhaps even financial reasons, that they've decided to go into a civil partnership, they've already rejected that ideal of marriage, and for them to come here and be told, actually, you're married here, it just feels wrong to me, ethically.
I think we would acknowledge that some couples in that circumstance might be pleased to have a level of legal protection afforded to the relationship, but equally many couples will have chosen to enter into a different kind of partnership for exactly the reasons that have been outlined, precisely because marriage is not appropriate for them, and they may therefore feel that that interim recognition of their relationship as a marriage is inappropriate, is not right for them. I can't speak for the Scottish Government, obviously, but I assume that they have judged that this is a pragmatic interim solution to offer some level of protection for couples. But to be honest, I don't have a different or better solution to offer just now, but would absolutely recognise that it might be uncomfortable for some couples.
Yeah, as Martin Lote said to the committee last week, for people who are in mixed-sex civil partnerships, it feels very unsatisfactory that their civil partnerships are going to be, even if they're just treated as marriage in Scotland rather than being actually marriages in Scotland for a while. It's a tricky area because it is a question of pragmatism and trying to get the best solution. So the issues, I think, are this. The idea from the government is that you commence Section 3 of the bill as soon as possible after the bill hopefully is passed by this Parliament. That might be in the summer. That introduces interim recognition as marriages. We would want to see, if that happens, we would want to see the rest of the bill commenced absolutely as quickly as possible after that, so that the interim stage is as short as possible. Now, Spice, in their briefing on the bill, have suggested that the rest of the bill might be commenced by spring next year. We think it could be done faster than that. You know, if the bill is passed by this Parliament by the summer, we see no reason why it shouldn't be fully commenced by the end of the year. So that's trying to keep the interim recognition period as short as possible, recognising that it's unsatisfactory for civil partnerships to be treated as marriages. The second issue is the one that you asked the previous panel about, which is why not amend Section 3 so that it says that the interim recognition is as civil partnerships instead of marriage. The problem with that is that civil partnership law at the moment is not complete because it misses out some of the things that are needed for mixed-sex couples, which are in marriage law because they've always been there. These are things that are added by Schedule 2 of this bill. Things like Rod Burns mentioned earlier on, the granting of parental status and parental rights and responsibilities to the husband in a marriage and to the male partner in a mixed-sex civil partnership. That's not there at the moment in civil partnership law. So if you simply change Section 3 to say that we'll recognise your civil partnership from England, say, as a civil partnership in Scotland, the law will be incomplete. Yes, you'll be recognised as a civil partner in Scotland, but you won't have that really important thing that Rod Burns mentioned, which is automatic parental rights and responsibilities and parental status through being the male civil partner of a woman who gives birth during that interim period. So actually what would need to be done is not just amending Section 3 to replace marriage with civil partnership, but also commencing some parts of Schedule 2 so that the real rights and responsibilities and protections that need to be there for mixed-sex civil partnership to work in the same way as mixed-sex marriage are brought into effect at the same time as the interim recognition starts. So then what you'd be doing is you'd be looking at, as soon as possible after the bill gets royal assent, commencing Section 1, which switches on mixed-sex civil partnership, and also commencing parts of Schedule 2 to give the practical protections that the law needs to provide. And that would give you your interim recognition, and then commencing the rest of it to allow registrations here in Scotland later on. So the start-up of the interim recognition would be more complicated. And really, I think it's something that I would welcome the committee asking the Scottish Government about whether that's feasible.
Wow. Tim, that's... Sorry.
Yeah, no, I was just going to say, I think that so much of our discussion ends up inevitably being a bit philosophical. And I think it's really important that we focus in on what being treated as in a marriage will mean and what protection that provides, because rather than the name, what we don't want is people losing rights or responsibilities that might ultimately protect them. But it's fascinating.
Thank you, Convener. Tim, characteristically helpful input there, and I might need to go back to the official report and just work my way right through all of that again, because I think you've given us quite a lot there, but it's very helpful. It immediately sparks two follow-up questions. As you say, the civil partnership that exists in Scotland between same-sex couples at the moment is incomplete because of the parental rights it does or doesn't confer. Should we use this bill to remedy that? I imagine it would be in scope to deal with existing civil partnerships as well.
That's an interesting question. Actually, the changes I was referring to are specific to same-sex couples.
Right.
Sorry, to mixed-sex couples, because we're talking about the case where a woman gives birth. And what should the status of her partner be, male partner, in terms of parenthood? One area of the law which does deal with an analogous situation for same-sex couples is the Human Fertilisation and Embryology Act, but that is reserved to Westminster. That is going to need to be updated as well. In fact, I think it may already have been done in the legislation that's been passed for mixed-sex civil partnerships down south, because that does cover a situation where, for example, a woman gives birth and her female partner is going to be treated as another mother of the child. So I believe that's already been extended to cover civil partnership. And in the case of mixed-sex civil partnership, obviously it's a woman giving birth, and her male partner needs to be treated as the father of the child, even if there was a different sperm donor, which is the kind of thing covered by that legislation. And I believe that extension to civil partnership has already been made by the legislation down south.
Okay, thank you. The other question I had was about commencement and the disparity between your view and that of SPICE as to how quickly we could implement it. I'm just keen and admit to have not read that section of the SPICE briefing properly yet, but what are the metrics there? What are the things that are going to cause the delays, and how can we mitigate those?
I would hope that this bill could be passed by the Parliament before the summer recess. Obviously, then there's either 4-week or 1 month delay before it can have royal assent. So then you're talking about sometime in July. The main thing that needs to be done before the thing is fully commenced is various bits of secondary legislation to alter things like forms that NRS use, registrars use, plus also training within NRS of registrars, and alteration of IT systems. So, for example, NRS keeps statistics on the numbers of same-sex and mixed-sex marriages, and they want to keep statistics on the numbers of same-sex and mixed-sex civil partnership, and that requires a tweak to the IT system. So in terms of the statutory instruments that need to be put in place, if they're affirmative, there's a certain time that it takes to go through the Parliament. But if those were laid before the Parliament in September, then there would be plenty of time to get those through before the end of the year, I think. And so long as NRS can then make their IT tweaks by the end of the year, that's why I think it should be possible to commence it by the end of the year.
That's helpful.
I suppose the term IT tweaks will send shudders round the room. What are these tweaks? What are you basing this assertion on?
Well, as I said, the one thing I know that they will have to change is, because I know that they do want to count statistics separately for mixed-sex and same-sex civil partnerships, and as I understand it, their system doesn't do that at the moment. Mm-hmm. So that will require an adjustment to the software. I don't know whether all of the systems that they use for entering the data and so on, because they're already there for civil partnership, and the only difference is going to be the two names, the two people will be of different sexes rather than the same sex. It may be that very little needs to be changed there because the forms for entering all of this stuff will obviously already be there.
But you don't know the detail of it? That's
I don't know the detail. No, that would be a question for NRS.
Okay, thank you. Are you content? Yes. Mary Finn.
Convener, and good morning panel. And I wanted to cover in a bit more detail the issue of gender recognition, and to ask the panel if you shared the view that was given by Professor Norrie last week, that the provisions regarding gender recognition are overly complex, and I'm happy to read out exactly what he said last week, if that would be helpful to panel members, because he questioned in his submission whether the full implications have been worked out when one party to an existing civil partnership or marriage changes gender. And in his evidence, he said that the bill replicates an overly complex provision to deal with the fact that civil partnerships were only open to same-sex couples, and if one obtained a gender recognition certificate, the relationship would have to end. And he suggested in his evidence last week that this issue would need to be considered in the gender recognition reform legislation that's out for consultation at the moment. So I wonder if we can maybe start with Tim.
Yes. So thanks very much for that question. It is an important one. When equal marriage was introduced, but prior to equal marriage, if you obtained gender recognition when you were in a marriage, or marriages of a mixed sex, you had to dissolve your marriage before you could get your full gender recognition. Otherwise, you would have created a same-sex marriage, which wasn't allowed. So when the equal marriage legislation went through 6 years ago, the Gender Recognition Act was amended to allow a process whereby you could get gender recognition while staying in your marriage, because it would just change it to a same-sex marriage, which is now fine. And yes, the legislation is a bit complex in that area. You have to allow...
Can I just interrupt you there and ask you the same question then I asked Professor Norrie? Is it complex because it needs to be complex, or is it complex because we are making it more complex than it needs to be?
So in my view, it could be simpler than it currently is. What this bill does is it replicates that somewhat complex process for civil partnership, because the changes we're making to civil partnership have exactly the same implications for gender recognition as the changes we made for marriage. That is, you'll be able to stay in your civil partnership. Now, I think the approach in this bill is correct. I think the right approach in this bill is to exactly replicate the way it works for marriage, because that's the basic principle of this bill. But I do think that it's potentially over-complex. Now, obviously, we strongly support the Scottish Government's proposals for gender recognition reform, and there are a number of things that are wrong in our view with gender recognition, which are covered by those proposals. The proposals don't touch very much on the issue of interim gender recognition certificates, which was the area that Kenneth Norrie mentioned last week. But we did have a quick look, and I can tell you that if interim gender recognition certificates were done away with, and arguably that could be done, then it would remove 8 sections from the Gender Recognition Act as amended by the Gender Recognition Reform Bill. So a considerable simplification to the legislation. But that question about the right way to do that, I think, is properly a question for the Gender Recognition Reform Bill and not for this bill. And the timings are, these bills are not going to overlap if this bill is passed before the summer recess. And so I do think that the approach in this bill is correct, to replicate the admittedly rather complex arrangements for gender recognition for married couples, to replicate those for civil partnered couples. And then we can look at that again and whether it can be further simplified in the context of gender recognition reform more generally, I think.
Yeah. And just before I bring in the other panel members, when you spoke about making changes to the gender recognition and removing 8 sections, would that simply make the bill clearer and perhaps more understandable, and simplify it, or would we lose something by doing that?
So just to clarify that, I wasn't talking there about this bill. I was talking about the Gender Recognition Reform
Act,
Bill
right, okay,
and the Gender
that's
Recognition
helpful.
Act. I mean, yes, it would clarify it substantially. There are all sorts of sections in the Gender Recognition Act currently, and they're replicated in the Gender Recognition Reform Bill draft proposal that deal with interim gender recognition certificates and how they are converted to full gender recognition certificates, because there are a number of different ways that can happen. For example, your spouse or civil partner dies. You end the civil partnership or the marriage. You agree that you don't want to end the civil partnership or the marriage, and so on. All these different cases are covered by different sections in the legislation. If you didn't have interim gender recognition certificates anymore, and most countries don't have something like that, then that's why you remove about 8 sections from the legislation. But it does need to be thought about, because there are questions about how do you make sure that you've got the right balance of rights between a trans person who is in a marriage and civil partnership, who's applying for gender recognition, and the feelings of their spouse or partner. Kenneth Norrie suggested last week, well, there are ways of ending the marriage or civil partnership without needing an interim gender recognition certificate, which is the way you do it at the moment. And this relates to divorce law reform. If we move to a system, as one of the earlier witnesses mentioned, other countries have, where you can, and which Ephraim Borowski mentioned is the case for Jewish religious marriage, where you can divorce simply because you attest that your relationship is irretrievably broken down, so no-fault divorce, then we wouldn't need interim gender recognition certificates, because the non-trans spouse could simply say, in my view, the fact that my spouse has transitioned means that the marriage is irretrievably broken down, and so I'd like a divorce.
No, that's very helpful. Thank you. The other panel members have a view.
Yeah, I don't think there's much that I can usefully add to what Tim said there, but I think we would, obviously it is a very complex area of law. I think we would agree that practically and in principle it's right that this bill replicates those admittedly complex provisions, and hopefully the legislative timetable should just about work out such that anything around this can be considered in the Gender Recognition Reform Bill.
Okay, thank you. Thank you, Camille.
Panel, I'd be interested in your reflections around allowing couples to convert their mixed-sex couples to convert their marriage to civil partnership. Elena, you spoke about some of the connotations, the serious connotations, I suppose, for some women around that. Do you have any reflections on allowing that to happen?
So, for so long now, the only option in terms of commitment has been marriage for mixed-sex couples. Because, like as we stated previously, perhaps the cohabitation laws don't go far enough in ensuring that protection for both parties in the couple. They see civil partnership potentially as an alternative modern institution, and I think that if it were on the table, everyone should have an option to transfer to that if that's what they believe, is the best thing for them. It might be that people have become married simply, perhaps their partner's gone into ill health, perhaps they've had children and they want to ensure that they're receiving the full legal protections that the institution of marriage can give them without necessarily buying into kind of the traditions and ideals of marriage that we kind of so often see. So yes, we would support the ability for people in a marriage to be able to convert to a civil partnership if that better aligned with the couple's commitment choice.
Thank you. Anybody else?
We don't have a particularly strong view on this, but if it was something that was on the table, I don't think we would have any objection in principle.
Do you think there's an issue of equality that I think when we had you were able to convert civil partnerships to marriage, and before now I would acknowledge that there's a different, that's a much different case, and there was obviously arguably a greater injustice that was being corrected there. However, would you have?
Yeah, I mean, I think that's right. I think that was a different context, and it was absolutely about correcting that sort of original inequality, if you like, and so there was a particularly strong case there. But yeah. I mean, as I say, if it's not something that we would object to at all.
Okay. Tim.
So I mentioned at the beginning that there was one change we'd like to see to the bill, and this is it. And I think our views on it have actually strengthened since we submitted our written evidence. There'll certainly be couples who are married because they needed the legal protections, who would have chosen a civil partnership had it been available. And that was the same when equal marriage came in. There were couples in civil partnerships who would have chosen a marriage, and they were allowed to convert. In fact, you can still convert from a civil partnership to a marriage, quite rightly. Now, the Scottish Government say in the documents that accompany the bill that the argument for being able to change a marriage to a civil partnership is weaker because they say, well, the big injustice was you had to enter a civil partnership as a same-sex couple up until 5 years ago. You couldn't enter a marriage, and that somehow they imply that's a bigger injustice than the other way around, where you're forced to enter a marriage if you don't want to get the legal protections. The problem with that argument is that, yeah, if you're one of the majority who think that marriage is the gold standard, then obviously the big injustice is not being able to marry. But if you're one of the minority who don't want to marry for all of the reasons that Eleanor mentioned and lots of people have mentioned in their written evidence to the committee, but you want a civil partnership, then the injustice is the other way around. So I strongly believe that on equality grounds, you should be able to change a marriage into a civil partnership. Now, we mentioned in our written evidence that perhaps that could be time limited on the basis that the biggest injustice is people who married before this legislation, this bill comes into effect, and who need now to be able to convert. But actually, Martin Lote made a very good case last week for it not being time limited. And if you don't mind, I'll just repeat a couple of things he said, because I think they're really important. First of all, take the situation of a couple who are from Scotland, a mixed-sex couple, and they go and work in Sweden, say, for a few years, which hopefully will still be possible despite Brexit. And in Sweden, they don't have civil partnership anymore. They only have marriage. So that mixed-sex couple, if they need legal protections, perhaps they have a child, they have to marry. Now they move back to Scotland 10 years from now. What they really would have liked is a civil partnership. So we need to have change available from marriage to civil partnership, even then, 10 years down the line. So that's a reason for not time limiting this. And the other reason that Martin Lote gave, which I agree, is that the cultural meanings of these things change over time.
Yes.
And it may well be that in 10, 15, 20 years' time, civil partnership will simply be much more popular, and that there'll be people who then want to change. Perhaps their family's view has changed, or the social circle they move in, the views have changed, and therefore at that point they want to make the switch. So we believe strongly that conversion from marriage to civil partnership should be allowed, and we now believe, contrary to what we put in our written evidence, that it would be better if it wasn't time limited. I'll just mention one other thing, which is that the Scottish Government raised a couple of technical issues with this. The main one is to do with the date at which the civil partnership is treated to have begun. So when you convert a civil partnership to a marriage, which is already possible, your civil partnership cannot possibly have started before the 5th of December 2005, because that's when civil partnership began in this country. So your marriage, the marriage that results from the conversion, is treated as having begun on the date your civil partnership began, and that won't be before the 5th of December 2005. But if you convert a marriage to a civil partnership, then your marriage may have begun in 1990. So the resulting civil partnership, what do you treat as the start date of that civil partnership? Well, if conversion worked the same way as it does from civil partnership to marriage, then you would say the start date should be 1990. The problem with that is that civil partnership law didn't exist before 2005. But this is not an insurmountable problem. So one solution, the UK government are proposing to do this. The UK government are proposing to allow conversion from marriage to civil partnership, at least for a time. And the UK government have actually suggested 3 different options for dealing with this problem I've just described. The one that seems to make the most sense is that you say that the couple are treated as having been in a civil partnership since the 5th of December 2005, and as having been in a marriage prior to that from 1990, if that was the beginning of their marriage, to the 5th of December 2005. And then you need some little bits in the law that ensure the continuity of those relationships, so that, for example, if they later dissolve their civil partnership, the civil partnership property, which is the civil partnership equivalent of the matrimonial property for marriage, also includes the property they accrued between 1990 and 2005. I don't think these issues are insurmountable at all. As I say, the UK government is proposing to do it, so we would very much like to see the Scottish government have a go at that as well.
Okay, thank you. That's really helpful. Mary.
Thank you, Convener. I just wanted to briefly cover the issue of the numbers that you think may wish to enter into a different sex civil partnership. You'll know that there are widely ranging views that have been suggested, and the government based their cost analysis of between 100 and 150. UK government figures put it much higher, and Tim, the Equality Network have based it around 500. So I wonder if I could perhaps start with you and ask why you've decided the figure of 500.
Okay, so the reason, basically, why there are these big differences in the estimates is that comparisons are being made with different countries, and the experience in different countries is different. The Scottish Government are clear that their estimate is based primarily on the experience in New Zealand, where they have civil unions, they're called there, with the same rights and responsibilities protections as marriage. But the number of people who enter civil unions in New Zealand is actually quite small. The UK government have based their estimates partly on the experience in the Netherlands, where they also have what's called registered partnership with the same rights, responsibilities and so on as marriage. And a significantly bigger proportion of people in the Netherlands choose registered partnership compared to marriage, as choose civil union compared to marriage in New Zealand. That gives you a figure for Scotland of about 2,000. Now, the UK government have actually come up with some even bigger figures, and they've done that based on a survey that they did, where people had said, yes, I would be interested in a mixed-sex civil partnership. We did a survey like that a few years ago and got a surprisingly large percentage of people who said they might be interested in a mixed-sex civil partnership. So you have to take these surveys with a pinch of salt, I think. The reason we came up with a figure of 500 was actually coming from two different directions. First of all, we said, well, maybe the Scottish experience will be somewhere between New Zealand and the Netherlands, and that gives you a figure of about 500 to 1,500. But we also looked at the proportion of same-sex couples who are still choosing civil partnership. As was mentioned earlier, that's 60 to 70 couples a year, compared to 900, roughly, same-sex couples who are choosing marriage. So about 7% of same-sex couples are choosing civil partnership rather than marriage. If you apply the same figure to mixed-sex marriage, if you imagine that 7% of people who choose mixed-sex marriage will actually choose civil partnership, I'm not saying they wouldn't choose marriage. These will be people largely who wouldn't even have got married. They're cohabiting at the moment. But if it is 7%, you get a figure of just shy of 2,000. Now, the experience in other countries suggests that the proportion of mixed-sex couples who go for civil partnership as opposed to marriage is a smaller proportion than is the case for same-sex couples. So then you take your figure of 2,000 and reduce it a bit because of that. That's how we got to the figure of 500 to 1,500. As I said in the written evidence, it very much at this point is a finger in the air exercise. We know that the experience down south is that several hundred couples have already, since the 31st of December, either registered a mixed-sex civil partnership or have signed up, submitted their notices to register a mixed-sex civil partnership. So that gives me some confidence that the figure might be closer to the 500 that we suggested than the 100 to 150 that the Scottish Government suggested.
And again, when it's first introduced, there may be an increase in the number of couples that want to enter into this kind of partnership, and then that might drop off and kind of normalise.
I think that's very likely. It's also the case, as Fraser Sutherland suggested earlier on, that as civil partnership becomes better understood, it might become more popular. So you might see a spike at the beginning and then a slow increase over years later.
Okay, that's helpful. Do other panel members have a view?
We have made no effort to try to estimate this, partly because there are a number of other figures out there and partly because it's necessarily looking at different contexts than our own context, and any kind of research here would be based purely on hypotheticals, which would not obviously necessarily give you any firm indication of future action. I think for us, the main thing is that although we don't know exactly what demand could look like. We know that there would be some demand, and even if there are low numbers, the main thing for us is the achievement of equality, of parity.
Yeah, the people have the opportunity to do it. Yeah.
So for us, while we know that there is some demand, the level of that demand is perhaps less relevant while the demand exists.
Okay, thank you. Elena?
Yes, no, I was going to say, the numbers that we have all come from the Equality Network, so glad that Tim is here to explain how they arrived at those numbers. But yes, I mean, when we're looking at demand, even if there is a small demand, it's still important to meet that demand if feasible. You know, extending equality for what is a minority doesn't mean the rollback of the equality for the majority. So we would support that.
Okay, thank you. Thank you.
Everybody happy? Okay. Thank you very much for your evidence this morning. That was really interesting and helpful. Our next meeting is on the 5th of March. We'll be having our final evidence session on the Civil Partnership Scotland Bill with the Cabinet Secretary for Social Security and Older People. And an agenda will be on our website on the 28th of February. We now move into private session. If I could ask the public gallery to clear, please.